But you know what I don't like when they don't keep it personality. And you see what you are. You know what? That's how I feel. I like to on the show, like it's the me.
Yes.
But then when we got off.
I feel like I've seen him. I don't know that I've ever seen
Yeah, I don't go with him. Yeah, you're on. I don't know.
Hey, Charlotte.
Thank you.
Oh, no, I don't.
Okay, thank you. It's called to order. Welcome everybody to the Cleveland Community Police Commission Rules Committee meeting. This is Thursday, April 20th, 2023. Welcome to everyone online and in our audience. We are starting at 5:07 p.m. So I'm just going to welcome everybody and call the meeting to order and to conduct a roll call of our committee members. Ms. Benito.
Present.
Mr. Donaldson.
Present.
And we also have our new co-chairs, Commissioner Chairwoman Ridgeway and Rodriguez present on the committee as ex officio members. So welcome everybody. I'm just going to, before we move to our guest speaker, I'm going to open into public comment. Is there anything on the agenda we need to talk about, or we can move it to a later period?
I don't want to move to it.
Okay. Yeah. So now we're going to move on to a presentation by Aqueelah Jordan. She is the Chief City of Cleveland Prosecutor, and we are blessed to have her here to talk about the Garrity Doctrine and also maybe glean a little bit of her wisdom about Brady. So thank you, Ms. Jordan, for joining us.
Absolutely. Thank you for having me. And allowing me the chance to talk to you all about Garrity and how it impacts the work you're doing. And so we'll just start the slideshow. I'm super excited about the work you all are going to be doing, so I always want to make myself available as a resource. So I'm going to put my contact information up at the beginning and at the end, so you can utilize me as a resource as you see fit, and I'll share my information. So there's my office number, my work cell phone, and my email address. So ways to get in touch with me if you have questions. Yes. Okay. So let's talk a little bit about Garrity. Garrity is a specific type of case law that applies to government employees. And it talks about the way they have additional rights, or their rights are looked at as government employees when it comes in line to questioning. We know that oftentimes employers can call you into the office and demand you answer questions. And so the Garrity Doctrine really looks at how those questions impact criminal prosecutions. And so for me, it was like, I know this committee is going to be doing amazing work. I know you all may decide that you want to order people in to answer questions for you. And so I'm like, let me talk to you about how that impacts what we do in criminal prosecution, so we can kind of all be on the same page. I don't want to impede your work, but I believe in informing people about how the work you do may impact our office. And that way we're all on the same page and working collaborating together when appropriate. So Garrity comes out of the United States Supreme Court. And the rights are intended to protect government employees from being compelled to incriminate themselves. So we know about the Fifth Amendment and the right against self-incrimination. What Garrity really does is function. It takes the 14th Amendment and uses it to apply the Fifth Amendment to government employees. There's a really cool website, www.garrityrights.org, that really kind of gives different examples, walks you through it. It's a resource that sometimes us attorneys talk in ways that make sense to us, but not everyone else. And I found this website really helpful in sort of explaining things and breaking it down a little bit more. So we're not just like, here's the case law, here's a case law, here's a case law. But of course, I'm going to go straight to case law. So Garrity v. United States, and the holding of that case really was that the choice given to the petitioner in that case really was, you either come in and answer these questions or you lose your job. right? And their employer ordering them in that way really didn't provide a choice, is what the United States Supreme Court said. It said it really took away someone's right to incriminate against incriminating themselves. And so the court said, we hold that the protection of individuals under the 14th Amendment against coerced statements prohibits use in substantive criminal proceedings, right? So at the core of that, what does that really mean? If the government employer orders someone in to testify or to provide statements in some sort of investigation, then those statements they're ordered in to provide cannot be used against them in criminal prosecution. So that's why I'm like, okay, let's talk about this a little bit more, because that really becomes important for the work you all do. If you all decide to order someone in to provide statements to you, then I can't use any of your investigation in the subsequent criminal prosecution.
Are you, is, to the chair, just a quick question. I'm sorry. Just a quick question, to the chair. When you say order someone in, is that the same as a subpoena?
Yes.
Okay.
And sometimes it's a little bit less than a subpoena. And that's what some of the case law goes into. If a supervisor says, hey, I want you to go talk to this investigatory authority, and you know if you don't comply with your supervisor's directives, that your job could be on the line or severe discipline. And some of the case law we'll talks about what that looks like. That could be deemed an order too. And thus mean that anything you all did would prevent us from using your investigation as part of a criminal prosecution or any derivative of that investigation. Yes, ma'am.
The chair. Well, one, thank you so much for coming in. We're really excited to learn from you today. So would you not be able to use any part of our investigation, or you just couldn't use the statement or anything that came from that statement?
That's a little bit tricky. It depends on what point you order that person in. And one of the good things that some of the prosperity of Garrity talks about is it just applies to that person, right? So say Officer A is the target of a criminal investigation, but Officer B may have information about what Officer A did. You all can order Officer B in, or any investigatory agency can order Officer B in to provide information. And I still have access to your information because it's a right against self-incrimination. Yes, ma'am.
The chair. So, so I'm imagining if an officer in the division of police, the division interviews the person, the officer, and they get information that then leads them to, let's say evidence of a crime. Like they say, yes, I'm making up nothing based in reality, but that, they say this is a weapon that I used to hurt somebody. Then can that then be used as a shield against prosecution if then the police department says, okay, we're gonna interview this person, get all this information, find out all this evidence, because then it can't be used against them? Is there anything that says that a department can't do that? And is that something that sometimes does happen?
So that's actually a really good question. And the answer to that question, of course, unfortunately, is it depends, right? It's going to turn on whether or not that officer was ordered in. So what we find, and what I appreciate about how Internal Affairs Unit of the CDP operates and how they, at least I've observed in my past 3 years, is that they offer officers the ability to come in and provide a Miranda statement. And officers can either agree to provide it or not. And then they conduct their investigation based off of that before they get into any ordering people in. So they understand, the Intelligence and Internal Affairs Unit understands Garrity. I've talked to them about it at length. And so they understand not to order someone in to provide a statement until after a decision has been made on criminal prosecution. Now, after a decision has been made on criminal prosecution, then by all means, they'll take that additional step of ordering someone in.
Why don't we, I just want to propose, if up to your preference, would you like us to popcorn in with questions, or would you?
Whatever works best for you all. I think sometimes it makes sense to you to ask the question right on the spot, so go ahead and we'll cover it then.
Okay.
All right. So Garrity was in 1967, which apparently was some time ago in the law. And so there are a couple cases that come after that sort of explain it additionally that interpreted Garrity. So we have Gardner v. Broderick that comes later in 67 that says an employer can't use a threat of discharge to the employee to get them to waive their constitutional rights. So you can't then come and say, well, I'm going to fire you if you don't. That's still going to protect you under Garrity if you're a government employee. Sanitation Men Association comes in, and then they say in 1968 that an employee can't be dismissed for refusing to incriminate themselves. They come back in 1970 and say, but if the employee statements are immunized, then you can order them in and can be used, right? So, I mean, what's the point of giving immunity if we're going to do prosecution? But that's what that. And then Castigar is the one that really affects some of the work you're doing, and that comes apart in 1972. And what Castigar says is, if someone is ordered in to make a statement, right, then any derivative use of that statement, so any part of your investigation that comes after that statement is made, cannot be used for the purpose of criminal prosecution. And that becomes the Castigar rule. So again, just a reminder though, that Garrity rights only apply to the public employee not being compelled to incriminate themselves. And that really becomes important in some of the additional cases that we looked at. So when we're looking at Garrity, it's important to talk about how it affects outside agencies' investigations, because oftentimes you're just looking at, well, the employer can order you in, but understand it's often the outside agencies is investigating it for criminal prosecution, right? So Garrity still applies if an outside agency is doing the investigation, which technically you all will be considered, if they are clearly subject to severe disciplinary action or termination if they refuse to answer your questions. So that's when that Garrity is going to kick in for those public employees. And then typically your own agency will order you to cooperate with outside investigators. So if your department has a rule that you have to cooperate with outside investigations, then that Garrity right is going to kick in and say, hey, anything derived from that or that statement itself can't be used against you in a criminal prosecution, right? And then also the reminder to employees that they should be careful that they're not assuming the nature or severity of the penalty, right? There has to be some rules in place that say this is what could potentially happen if you don't cooperate or if you don't come in, right? So one of the cases I really appreciate is the Ohio Patrolmen's Benevolence Association v. Mentor, right? And in this case, an officer was being investigated and subsequently charged. And what this really talked about is that derivative use and Garrity being self-incrimination. And so what Ohio Patrolmen's Benevolence Association came out with is that Garrity precludes the use in subsequent criminal proceedings against that employee. But it also went a step further in saying, but you can use that employee statement against another employee, right? So that goes back to the Officer A, Officer B example. If you're investigating Officer A, he can't be ordered in to testify and there still be criminal prosecution, but Officer B can be ordered in to testify. And you can use Officer B's statement because it's, again, self-incrimination. And so that ends up being a really important case. And of course, it's Ohio, which makes it more binding and persuasive jurisdiction on us. And there hasn't been any cases overturned that since 2000. So that's really good case law for prosecutors. So Ohio, and this talks a little bit more about it, the Ohio Supreme Court rejected this idea that you can invoke someone else's self-incrimination rights, which really becomes important in some of the investigations that the Internal Affairs Unit does, right? And instead, information obtained from the defendant's own Garrity statement can't be used against them, but free game and using it against anyone else, right? But it's important to remember that Castigar still sets up this really complicated two-pronged test for prosecutors, right? And so the first element in Castigar is that under grant of immunity, matters related to criminal prosecution, the state bears the burden showing that the evidence was not tainted, right? So we have to establish, once someone has said, hey, there might be a Garrity violation, the burden then shifts to the prosecution to say, no, there was no Garrity violation. That's the first part, right? And then we have to prove that all our evidence derived from outside of that Garrity statement before we'll be able to proceed with our criminal case. We have to deny use of the accused's own immunized statement, and then we must affirmatively prove that all of our evidence came outside of that statement. So that's why the Internal Affairs Unit does a really good job of saying, hey, we're going to offer a Miranda interview first. And then you can either come in under Miranda warnings or you cannot. Then we'll present to the prosecution. And then after prosecution makes a decision, then we'll do Garrity interviews if they're not going to pursue criminal prosecution, which is part of why IA cases take a little bit longer sometimes. Jackson is another case that talks about, and it's an Ohio case, that talks about if the testimony is compelled. So again, if you're ordered in, this is not considered harmless error. So sometimes as an attorney, you're like, well, the mistake was harmless. I didn't know. Jackson came in very quickly and said compelled statements under Garrity are not harmless error. And so that will be charged to the prosecution. State B, and I'm always butcher this name, Bracius, is another one that held the defendant's statements can't be used against them. And it went a little bit further and said if the prosecution uses the defendant's immunized statements or any evidence, right, that's impermissible, and eventually threw out that case. Yes.
To the chair, what constitutes a statement? Is there any question that if something happened on a shift and the supervisor says, hey, what happened on that shift today? Is that a Garrity statement?
Yeah, so that's where the question about what is the penalty of not answering that question going to determine. Because remember, Garrity applies if you're under the threat of termination or serious penalty from your job. So the answer to that question is going to root on what is the penalty for not answering the supervisor's question. Is it going to be serious discipline? Is it just write up what sort of penalty is associated with that? Does that make sense?
Mostly, I guess what I'm trying to parse out in my head is does the question have to be coming from a place of an investigative question of somebody suspects that something happened and now they're asking questions, or is it, something as simple as, hey, where's your body cam footage for this day? We can't find it. Right? Or normal questions that you would ask after an incident, but not because you're targeting someone as a potential target of an investigation.
Yeah, I think in an instance like that, most of the rules of CDP are going to say that's not going to subject you to severe discipline.
Okay.
And so since it's not going to subject you to severe discipline, the Garrity is not going to apply.
Okay. Thank you.
Okay. And so this is another Ohio case that just really clarifies that any sort of derivative use of Garrity is going to make prosecution difficult. So State v. Graham talks a little bit about coercion and the extent of coercion and getting these statements from officers. So what if you're not ordered in to provide a statement, but you're kind of coerced into providing a statement? And so Graham clarifies, and this is 2013 case, that when you're dealing with coercion, the employee claiming that coercion really has to show that they believe they were compelled to make that statement or they were going to lose their job. And it has to be objectively reasonable belief, right? And so those are some things that will help in the instance of someone claiming coercion. Well, I thought I had to come in and make the statement. And CDP does a really good job of making it clear you're being ordered in to provide this versus would you like to come in and make a Miranda statement? So that really helps out a lot in clearing up any sort of question of were you coerced? And they often put that request in writing. So there's no further confusion, right? There's usually an email sent to that officer, right? And furthermore, evidence of the express threat in the policy. So I think that's why it goes back to what does the disciplinary policy say? It's going to talk about what the coercion level is under that, right? And so, but Yakari is a case that's sort of a derivative that comes before Graham, and Yakari talks about an employer isn't forbidden from obtaining a voluntary statement. And that ends up being really good case law for us in the terms of asking officers to come in to make Miranda statements, right? So you've been warned about your Miranda rights. Would you like to come in and make a voluntary statement? And Yakari says we're completely within our rights to do that. I think it's important to mention OBI and drug tests here because we have to remember OBI tests are not considered testimonial, right? And so Garrity does not really relate to OBI because it's not a statement being obtained when someone is performing standardized field sobriety tests or performing a BAC. This is not a statement, it's can you complete this test? And so the case law has held that this really, Garrity does not apply to this. And it's well settled that the Fifth Amendment only applies to testimonial statements, and OBI tests are not considered testimonial. Another thing that I really like about some of the case law in Garrity is that it reminds us it does not protect you when you lie. So if an officer is ordered in to make a statement and they lie, there go all your Garrity protections, right? So Garrity does not protect you if you're making false statements. You can be prosecuted for the false statements and your Garrity interview can be used against you. There's another number of cases throughout the country that have ruled that, and a number of cases that remind us that the Fifth Amendment doesn't shield from perjury or false statements. So yes, ma'am.
So the false statement could be, it invalidates everything.
Yes.
The entire testimony.
Once you lie, you have no more Garrity protections whatsoever. We always encourage people to tell the truth, but sometimes they don't. And when they don't, you lose all these Garrity protections that you previously had. So even if an officer was ordered in, initially we declined criminal prosecution because there wasn't enough evidence to proceed in that prosecution, but you get to a Garrity and you lie and we get some additional evidence, now we can take another look at prosecuting you.
And are the officers told about these consequences before they had their asked for a testimony?
That's a good question. I'm not sure. I would assume they're told to tell the truth. I would assume they're officers and they know they should tell the truth, but I don't know the answer to
This
that.
would be a good incentive. I mean, other than the virtue of telling the truth, but so.
Yeah, that's what I'm not sure. I can ask Internal Affairs and get back to you.
Okay, thank you.
And that's kind of the end of my little spiel. Here's my contact information again. I really hope to be a resource if you should need me. But thank you.
Thank you.
Chair Ridgeway.
Okay, to the chair. I want to simplify this just a little bit.
Yes, ma'am.
Okay, so basically, Garrity protects government workers.
Yes.
That's what it does.
Yes. From criminal prosecution.
From criminal, even if there is some criminal action or intent.
Well, it only protects them from incriminating themselves.
Okay.
So we can still prosecute them. We just can't force them to incriminate themselves.
That is a fit.
Yes.
Yeah, that makes sense. Okay. Could I ask, what is the relationship between Garrity and qualified immunity? If there's any relationship at all, I guess that kind of goes into what?
Yeah, qualified immunity is more so, at least from my perspective, and a lot of people disagree with me, qualified immunity is more so civil, right? You can civilly not be sued. We're criminal prosecution. So yes, there are some who argue we have a higher standard, but qualified immunity doesn't necessarily protect you from criminal prosecution because you committed a crime.
Does qualified immunity elevate the criminal standard, or?
So the criminal standard is still beyond a reasonable doubt. Some are going to argue, and trust me, I've been in enough trials with these police officers now to know their attorneys are going to argue, but qualified immunity, they're going to say it to the jury, to the cows go home. It's my job to remind them qualified immunity is a civil standard. We're in a criminal prosecution. Our standard is beyond a reasonable doubt. The reality is it's still tough to prosecute police officers. We do it, right? Get a lot of flack for it, but when it's appropriate, we do it. But it's still hard at times to convince people that if an officer did something wrong and illegal that anyone else did, that we should hold them responsible for that.
I just have another question. I was following in the media with one of the more recent cases for the two police officers. What was the outcome with that, or has it been resolved?
Oh, I'm trying to think which two.
The assaults.
The assault, right.
From the, it was hunted back from the FBI, and then there were two officers that were charged under Cleveland Code
Thank you.
for assault.
That's still ongoing.
Still ongoing.
Yes.
Sheriff, oh, sorry. Sheriff, I may,
Oh, go ahead.
whoever, yeah. Yeah, so I'll defer to the commissioner first.
I was gonna ask if we were gonna have a conversation about Brady also.
Yeah. I was gonna bring that up, but first I have a question. I'm gonna take a liberty because I've heard this for the last 6 years from the community members, and it's an important question to ask. I know we've changed administrations, we've changed prosecutors, and the question offered before us is, people are aware that 615.13 interfering with civil rights is a local Cleveland code. I believe it's an M1. But what we don't see is when county prosecutors fail to, a grand jury doesn't bring back a bill against officers, what we don't see is local prosecutors pick up any chance of a misdemeanor charge off of a grand jury that failed to indict on felony charges, specifically interfering with civil rights. And we've heard all kinds of reasons for that over the years. So in the instance of officers, like, let's just give a scenario, right? Let's say there's an OPS complaint of a false arrest, right? With the potential of it being interfering with civil rights, do you guys look at that first? And then what is your standard as a new prosecutor for when this applies to police officers?
Okay. So we don't per se look at OPS complaints. We only review the information that's brought to us by the Internal Affairs Unit. So OPS will have to kick it back to Internal Affairs, indicate that it's something criminal, and then Internal Affairs will have to bring it to us. Typically, the way things happen in Cleveland is that if there's an offense or a crime committed in Cleveland, it actually comes to your city prosecutor's office first before it goes to the county. So the police cases you see that have originated in Cleveland that have been referred to the county prosecutor's office in the past 3 years have been referred by our office. Now, whether the county prosecutor decides to pursue that or not, that's a question you have to ask Prosecutor O'Malley. But we forward it to them for prosecution. I can guarantee you I have forwarded cases to the county prosecutor's office for prosecution. Do we necessarily consider to charge those as misdemeanors if the county prosecutor's office declines? That's a more complicated question because we have to look at it in case-by-case basis. The first thing, if I'm a defense attorney, I'm going to say at trial is, well, they sent this up to the county prosecutor's office and the county prosecutor didn't charge, so why are we here? Right? That's the first thing that's coming out of the defense attorney's mouth. So we are looking at all the facts and evidence and circumstances and making a decision of, after we've sent it to the county and said, we believe this rises to the level of a felony, if we're going to pursue it as a misdemeanor.
I have a question about, so during these questioning of the officers, they've obviously, in addition to their like constitutional rights, can they have a lawyer present? Is that okay? What about the interaction with their union representative?
Every interview I have watched with an officer has had union reps, oftentimes more than one, their attorney present, support present. There's usually 5 or 6 people in the interview supporting these officers. So all their rights are protected during these interviews.
That's what I wanted to ensure, that wasn't something just.
It is not something
this
wrong.
Goes back to Ms. Benito's question, right? What if something is found out in the process of just normal work? How do you ensure Garrity at that point?
And remember, Garrity is just if we're ordering you in or compelling you to testify. So it's going to come back to what are the penalties associated if they don't answer these questions by their supervisor. And typically those aren't going to rise to the level of what's deemed severe.
Thank you. Do you want to move on to the Brady portion?
Yeah.
Do we have any more questions from the audience? Mr. Jordan? You have a question?
Not yet.
Oh, not yet. Great. Okay. Well, we'll look forward to some questions. So I think we'll just move on to Brady. And we had someone from the county prosecutor's office already here. We had Carrie Howard. So maybe just give us an overview of your perspective on Brady Giglio violations and how they arise in your work and how that information is shared maybe with the defense.
Yeah, so Brady Giglio is a little bit more complicated because I, in my naivete, thought when I started this position, oh, I'll come in and there'll be this wonderful Brady Giglio list and we'll just be able to put it out. And no, it doesn't exist. I was just like, oh, okay. And then at the time we came in, we didn't even have a case management system when I started here. And that was in 2020. And so what a case management system does is it allows you to have cases that you can put party flags in, that wasn't present, and that just got up and running in the last year. So my office is essentially starting from scratch, going through all the disciplinary reports, and I believe CDP provided us a backlog of reports for about the past 20 years. Combing through those reports, then reaching out to internal affairs or CDP and saying, hey, here are the officers from these reports that we believe may have Brady Giglio information. Can you send us over their file? Reviewing the file, making a determination that there's a Brady Giglio information, then entering them into the system as a party flag to say this officer has a concern. It is a very intensive process.
So, but it does sound like that there was the creation of some type of compilation of this information?
No. The compilation I'm referring to is CDP sends out list of all their discipline. And it can be something that relates to truth, untruthfulness, or it could be you didn't turn on your body cam. So what we do is comb through those lists and then reach back out to CDP and say, hey, this is something we believe may be an issue. Can you send us over that case file for that? And then we have to review the entire case file and make a determination.
So where is so there's no kind of keeping of that information? Because I'm assuming if you found and determined that the officer has a Brady Giglio issue, that might be determinative of their entire, right? That it's not gonna.
Yeah,
Where would that, like, for your, say you found Officer A.
Yes.
In like 1990 or someone found that.
Yes.
And they're still working and it's 2000 and Officer A comes up again as a witness.
Yes. Now that we have a case management system, we now flag Officer A in our case management system. So say Officer John Smith has been flagged in our case management system. Now whenever one of our prosecutors enters John Smith into our case management system on one of their cases, it pops up with that flag and the documents associated with that flag so we can send it over to defense. But like I said, we still have a long way to go.
So you have to know the name of the officer in order to, but is it theoretical that since you've done so much hard work and it sounds like very, very difficult work, and would this information be helpful? Because I don't know, Jason, it's maybe we're tasked by the charter as a commission to come up with a public database of these Brady Giglio violations and officers. And you can imagine if we had to recreate the entire process, right? So is there anything that would help us, get further along the process from the work from the information contained in the system? Is there, like, if I ask the system, can you give me the named officers in the system that are flagged, will it be able to do that?
Our case management system doesn't do that. It's not that advanced. I wish I had an easier answer for you because that would make my job a heck of a lot easier. I'm working on getting one. I just don't have one right now.
But is it something, can we go, like, to the officer, I'm just trying to imagine, can it say, is there a sequential order for the office that you can look through every file, or do you have to search for a name? Are the files all there?
Our system is set up so you have to search by name. That's the only option this case management system gave us.
But theoretically, we could have someone input all the names of the current Cleveland police officers, and then if a file comes up that's a red flag, we'd have all that information.
Theoretically, yes, but I'm also going to give you the small caveat. I think our system has been live for less than 6 months. Don't quote me on that. It may be closer to a year now, but our case management system has not been live for that long. So there's not a significant number inputted right now.
Okay. Do you have an estimate, you think?
No.
No? Okay. Ms. Benito?
No, just a quick question. So 2020, you didn't even have that case management system in place. At the point that you began, you didn't go back and do an archival piece, you just moved forward. So whatever you have dealt with since the case management system became live, that's the only thing that's in there right now. Have you added anything prior to?
So yes and no. What we asked CDP for was for their historical list.
Right.
So we went back and got lists of all their previous
Oh, you
disciplines.
do have-
Now we're working from this point backwards because we think the people employed now are probably more important. So we are working from present day back.
Okay.
And I'm not exactly sure how far back we have, but I can find out.
I have two questions. So the first is, what process are you guys using to make the determination that an officer's should be added to the Brady list? Do you guys have like a committee? And if so, how often are you guys meeting? What's, are you just taking in like current information, or is that committee also using, taking it chunk by chunk? And then I'll let you into that.
Okay. So our staffing levels don't permit us to have a committee. Remember, there's only a certain number of city prosecutors that are allowed by the charter, right? So we can only have so many of our staff members, period. I think we're 22 or 24 prosecutors for our entire office is all we're allowed. So the administration was actually nice enough and supportive enough to allow us to hire a prosecutor who is focused on that. Now, unfortunately, our staffing numbers took a dip, and so that prosecutor had to go into a courtroom. They are now out of that courtroom and back to working on this project. So that is the prosecutor. They have amazing credentials, decades of prosecution, worked certified OPATA officer, so they have police background, worked misdemeanors and felonies, just an incredible resume and skill set. And that is the person that we charged with doing this work. Stephanie Hall.
What's the last name?
Hall. And then once that flag is being determined, once Prosecutor Hall or Attorney Hall, Prosecutor Hall?
Same.
Okay, great. Says, okay, yes, I think that this person should be added to the Brady list. And then at that point, it's added to the flag system.
Yes.
Is a letter sent to the Division of Police?
That's the part we're still working on. So, like I said, we're still filling our way out through this. We're trying to figure out what the best practice is. We talked to a couple different jurisdictions. Eventually, we will get to the point of sending letters. Right now, our priority has been, can we identify who these people are?
Right. And so, as has been said, we're tasked with creating a public database of officers who have these potential Brady violations. And so as you are now in this process, is that something that you guys would be willing to, once you have, I understand that it's going to be an ongoing process, it might not happen quickly, but as you identify, new people that you're adding, would you be willing to share that information with the CPC?
I think
we can add it to our.
I think that's something I would have to ask my supervisor because I'm not sure if there are any contract things that prevent us from doing that. So if you could give me the grace of asking him, I'm not sure.
Just, through the chair, the prosecutor. What, Prosecutor Hall, what is the standard? So we get all the discipline too, and you can't always tell. So do they have a written guideline or saying, here are the 10 things that we're saying if you have in a discipline that you are being flagged?
So she's looking at everything by case basis. We know convictions automatically get flagged, right? And then the other thing she's looking at is instances of dishonesty, because that's really what the Brady Giglio is about, right? Is it something that's impeachable? Is it something that shows your propensity for dishonesty? And so those are the sort of things she's looking at. So we didn't feel like a rigid list of X, Y, and Z could really accurately capture everything.
Is it possible at this point going forward, once these officers are flagged for, I think it's the same question, for us to be notified in some way before the information kind of disappears into the database again?
And again, the same answer. I'm going to have to check with my supervisor because I need to make sure there's I don't know the police contract. I don't know what's in there. I got to make sure there's nothing that would create a conflict with that.
In addition to the disciplinary files, does she look at any other public documents to flag these officers?
Eventually, we will, but right now, at least the discipline files give us a place to start, right? So we're first going to start, and sometimes something may pop up in the media before it pops up in a discipline file. So whenever we see one of those news articles or stories like that, we forward to her, because oftentimes, well, not oftentimes, sometimes you'll see our officers will get into trouble in other jurisdictions, right? They may catch an OBI or something someplace else, and that becomes media worthy. So we forward that media article so she can begin to look into that.
Just one follow-up question. So do you know of any other place? Right, I imagine that, and I apologize because we're lay people here. Are there any other avenue places or sites in the legal process in which the violation would be found out other than from the prosecutor? Like, could it happen during trial that was unknown to both sides, or could a judge overrule and say, no, this officer has what I believe a Brady violation?
So I was about to say, no, it couldn't happen in trial because we would have to turn over discovery. But now that you mentioned that, I'm recalling a news article where it did happen in a trial. There was a judge who found an officer not credible when they were testifying. And we went back and said, hey, Stephanie was looking at getting that transcript pulled and looking at that because now we have a judge that's deemed the officer not credible, and so that's something that was being looked at.
To the chair, that's a perfect lead into my question is, so we know that, like, let's say this just happened, and fortunately the person who it happened to was had the resources to go to OPS and file a complaint, right? What is your reporting requirement? Like, if you see misconduct, right? So, for instance, they violate the search and seizure policy, so you get evidence excluded. Well, yeah, that's a bad break in a case. But if it's a clear violation of CDP policy, why that got excluded, that should be disciplined. Do you guys have a mandatory report? So you see policy violations all the time, but what happens in this gap in the courts is it never gets back to the chief that it should be disciplined for that. It's kind of just a part of doing business in prosecution, right? So an officer did something, right? The worst case scenario in a courtroom is it gets excluded as evidence. But that officer maybe also should be probably disciplined for the way they got that evidence. So you guys see a window that we don't see. Do you have a mandatory reporting clause? And do you ever report misconduct that you see as prosecutors?
So there are a couple layers to that. One, we don't have all the CDP policies. So we don't know what the officer's internal policies are to say, hey, here's a violation of the policy. We do not have a mandatory reporting guideline or duty. However, my office is proactive and say, if we see something wrong, if we have a concern about an officer's conduct, we're calling up that chain of command because that's how we achieve equity and justice in the criminal justice system.
So I know that before 2020, there wasn't really, it sounds like a system for tracking Brady disclosures. So was Brady disclosures not happening, or it was just not being tracked?
I wasn't there, so I don't know.
Okay.
I can't answer.
So I think that for me raises a question of, is there any review of previous cases to see where prosecution might have happened and a Brady disclosure wasn't made? Because that would be concerning, because your office is still responsible for the prosecutions that have been made prior to your term. And so if any appeals are coming, and they're saying there was a Brady, there wasn't a Brady disclosure made, is that something, are you guys doing any review? I imagine it was pretty startling for you to come in and be like, oh, there's no Brady information here, but, I agree with you that as part of criminal justice reform, if we know that that's not happening, should that mean that some of those cases should be reviewed?
So our primary concern has been, how do we prevent this same mistake from happening moving forward? We want to get that solidify first before we go back and start doing historical reviews, right? Because it's really important not to continue with the practice. We want to stop that now. And so once we have a better handle on that, then absolutely. Now, if something were to come up in a pending appeal, absolutely we would look at it. Because again, we have a moral and ethical obligation to our community that we're trying to uphold. You're welcome.
Thanks for answering all these questions.
Absolutely.
Do you have any more questions?
Bless you.
Microphone if you want. Lou?
Yeah. Yeah, thank you. In that case, we know that consent decree has been on for a while, since 2015, basically. But prosecutor office has a different people working on, so definitely there is a gap, or more than one, we can imagine. Is there any way to ensure that the back records you have received, your office have received, is complete? Or is there any way you can actually make sure that you get whatever the information in the past which they have not submitted to you?
So that's the process and thank you for that question. That's kind of the process we're undertaking now. That's why we're taking the time to go through everything. We requested all the prior discipline from CDP that they had available to them, and we're going back through all of it. So that is our first step in this process. And then once we complete that, we can do the additional steps of looking to see, are there past cases that we should have looked at?
The concern will be things keep going on every day. So if we do not catch these things in time, some of the people's behavior would have been prolonged too long unnecessarily. So for the community, the concern will be, how fast can you catch up?
And that's the one that unfortunately I don't have an answer to you in terms of time frame. I understand the community concern because I'm part of this community. I want us to have all the accurate information. I want us to hold everyone that should be held accountable, because we have really good police officers at CDP who are getting a bad rap because we have some officers that are not as good as our really good police officers. I think the best way to support our amazing officers is by showing that we are addressing those who are bringing down the esteem of the department.
Do you have any questions for Anne?
I don't. I'm just really excited for your work. I'm really appreciative that you all let me come in and talk to you. I hope it's helpful in the work that you're doing, because I think you're going to do phenomenal. So I'm just excited.
We might have to come back.
Sorry, I have another question. Throughout the time, if people's bad behavior has never been discovered, these people may get promotion. So that means these people could have been in the middle of the system, and they will have the power to influence the new people coming in. And actually, that will create a bad culture continuously. So if we cannot stop that, then that will just keep making more of the discipline scenarios, which is not encouragement to all the good police officers. And so we wish this can speed up a little bit, because we really want the positive reinforcement. We want the good officers to get encouragement, not to get frustrated because a lot of ongoing investigations. Then we have a new investigations. This is not really a happy situation. Plus, we already don't have enough police officers right now on duty. So this will create extra stress for them to really worsen their mental health. This is a big concern. Thank you.
And I think that's one of the really good things about so many different entities doing this work, right? You have your committee and your board that's going to do phenomenal work. You have OPS is working collectively to try to weed some of this out. You have the internal affairs unit, right? You have the monitoring team from the consent decree. I think with all of us working collectively, we're going to get this work done.
Yeah, I think to echo Ms. Liu's concern is that for this to work for you, right? Because you obviously don't want to come upon this information when you're prosecuting a case,
Right.
right? This is predicated on the integrity of the police system in being able to find its own, like to hold accountable its own officers. I guess I had a question. Maybe I'm just so if you know, if a complaint goes to OPS, and only the civil ones go to CPRB, the criminal goes back to internal affairs. Am I understanding? Could an officer have a Brady Giglio violation in the civil realm? Like like how do they determine which
Yeah.
is civil and criminal, and to put it in those two traps?
So
Unless it's something determined.
yeah. The civil is going to be, is it strictly a policy violation? So that's the CDP policy question. Is it a violation of Cleveland Division of Police policy? It's a violation of policy, then it's not going to come to us for a criminal review. The prosecutor's office is only looking at criminal violations. However, that CDP policy violation may ultimately result in discipline. If there's discipline that comes about as a result of that CDP policy violation, then that disciplinary notice that comes out is going to come to our office. And we're going to take a look at all the disciplinary notices and determine if that's something we want to look at.
So if an officer, say, because one of the Brady violations is dishonesty, right?
Yes.
What if that officer lied during the criminal investigation of, the civil investigation through CPRB? How would you get that information? And would that information be pertinent to a Brady violation?
I believe anytime an officer is dishonest, that is also CDP policy violation. So that could result in discipline. So that's how we would get that notice. It would come out in that disciplinary notice, and then we would request a file.
But it would require the CPRB voting in the majority to bring it to a discipline.
Yes.
Thank you. Do you have any? Oh, Ms. Lou again.
Right now, we can only talk about your experience right now because I don't think you can speak on behalf of other coworkers. Throughout the time, from your own, the cases you handled and from you have seen, if there's really a case for you guys to prosecute, do you or your coworker will get a pressure not to prosecute?
No. So my role as the chief prosecutor is to review any criminal offense committed by a city employee. And I take that role very seriously. You can ask my boss because he has weekly meetings with me where I go over what's been presented to me and say, here's what we have, here's the evidence to support it, here's how I think we should move forward based on the facts and evidence and circumstances surrounding that. I don't take anything personal per se. I know when I make a decision to charge, there are going to be not nice things said about me, and I'm okay with that. That's part of my job, right? But that's the promise I make to my community, that I will make those hard decisions. Now, the flip side of that is I am so grateful for body camera footage because I can't tell you how much body camera footage that I have watched that has been able to say very clearly, that officer did not do what they're being accused of. And it allows me to close out cases and be confident. I need to be able to sleep at night and know that I made the right decision of whether to pursue charges or not to pursue charges. And I can promise you, body camera has helped me sleep better at night in my decisions not to pursue charges either at my level or refer up to the county. I have had the support of my supervisors in every decision I have made in whether to issue charges or not issue charges. And that has been very comforting to me, knowing that they value my opinion, they value my analysis, they're willing to talk through the cases with me and allow my expertise to make that decision with their guidance.
So you are saying you have never experienced anybody trying to change your decision?
I am not. We've talked it through. I've answered questions. We've analyzed it. My supervisor has even watched video with me at times. Like, let's go over this video. Tell me what you're seeing. Tell me why. Tell me your analysis. I've had support from Chief Griffin, and I appreciate that.
What do you do when you find out the video footage, body cam footage? You can tell somebody turn it off, then later turn it back on. That means there will be a gap.
I have not experienced that yet in one of the cases I've looked at when I'm ready to charge, only because there's often multiple officers on a scene. So I don't just look at that officer's camera. I look at everybody's camera. I'm watching everything to see what is going on, what are the different viewpoints. In addition to that, again, I gotta brag on IAU a little bit. They've gotten used to my type A and saying, is there surveillance camera? Did any of the businesses around have camera? Did you go get that? Who are the other witnesses? I see a store clerk there. Did you talk to them? And IU has been incredibly receptive to going back out and talking to those people, getting me additional footage, because I need to make sure I can answer every question in my mind.
So if this happens, you just go with other cameras to provide you information. You don't really think this particular camera has a 5 minutes or 1 hour gap is an issue to address?
I haven't seen gaps in video footage.
No, I'm saying if that happens.
If it happened, then I would have questions. Absolutely. But I haven't, in the cases I've reviewed, I haven't seen gaps in video footage. If there has been an officer that didn't turn on their body camera footage, I've had another officer's body camera footage to review.
Right, so we know you will have enough to go references for you. But people are concerned because if you have certain officers, they tend to have their body cameras off for a certain amount of time. It happens, maybe not every day, maybe just a few times a week or something like that. Would you guys consider that's an issue we should actually address on behalf of the people?
So I think one actually realistic, if I can intercede. One, there was a recent CPRB case for, I believe it's Gilbert. And in the process of investigating, OPS discovered that there were multiple officers who had not properly docked. It wasn't that they turned off their body cam, but it wasn't properly docked, so there was missing camera, which makes your job, everybody's job, harder. If that, I don't know if it's Lu's asking, if that is something that you discover, is there, or any type of kind of violation you discover in your search for the prosecution's case, would that be something that you would go back to the police, and especially when it's something of a systemic nature? What would generally be your process in dealing with
potentially, right? If I were to see something like that and then see that same officer another case down the line and that body camera is off, then I would probably be asking internal affairs questions like, have we looked at the pattern about whether or not that camera is consistently off? What is your sort of, because it would be a legal question of, would that rise to the level of dereliction of duty, right? Would that consistent turning off of body camera footage rise to the level of that criminal offense? And I'll be honest with you, dereliction has been incredibly difficult to prove in this court. Doesn't mean we're going to stop charging it, but it has been difficult to prove. So I would have to make the legal analysis of, is there enough there to rise to the level of something criminal as opposed to a policy violation?
Right, but regardless of charging them, would it be something that you would tell?
Possibly. If it's something I saw that was consistently wrong, yeah, I would ask IAU to, because we don't investigate as prosecutors, right? We charge someone else with doing that.
Right, but I think that the public wants some assurance that if you come up with some information that's very important, that we should share it with the right people that can help that officer come into compliance with that. Okay, so are there any other questions? There's no questions. Thank you, Ms. Jordan, so much.
Thank you all so much for having me.
Okay, so now we will move on to old business. We are going to have a continued discussion of draft amendment procedures, section 2, specifically section 2.8. This section is about public speaking, commentary, and media relations. It was returned to the committee by commission vote. Specifically, before, it was, I believe, the last paragraph that was of primary concern. I'm open to going through again just to make sure we didn't miss anything. So thank you to our commissioners that voiced their concerns about the last portion. If we can read that, I don't know if it's for the sake of people that are listening, if we should read more of this portion out. So the portion that was contentious was written reports and statements approved by the majority of the commission shall include the names and signatures of all commissioners regardless of their vote. All right. So now I'm going to open it for further discussion. The concern, I believe, at the commission meeting is that the request was made that the commissioners, regardless of their vote, be able to sign the report or statement, but that they be given space in the form of a paragraph or some written space to provide the rationale for their dissenting view. Does everybody agree that was an accurate assessment of what was requested before? There were discussions about can the diversity of their opinions be expressed that way. So now I open it for discussion. Mr. Gilbert, could you first explain, I think there was already conversation about what do these reports and statements, and can you go through the types of documents that we would be affixing our signature upon?
Yeah, I'm gonna, so that was a question raised in email by Commissioner Donaldson, I believe. So I'll just bring up what I used as an example in that. All right, so where did this first come up? I think I mentioned in the public meeting that there's a historical precedent for this. And that precedent, the biggest controversy we ever had with this has been over a letter. So there was a vote to send a letter to the DOJ by the previous commission, and this vote was in July of 2021. And it's basically asking the DOJ to do an investigation into the shooting death of Arthur Keith, which happened November 13th of 2020. It was not a unanimous vote to send this letter. There were 3 dissenting votes. And the original draft of the letter left those 3 names off of the letter. When that occurred, there was a significant level of emotional and, well, I'll just say unhappy. People were very unhappy that it was destroying the unity of the commission. The vote passed, and they were adamant that all names had to be on there. So in the end, all names ended up on there for that specific reason. It was talked about that your vote is your dissent. So you are able to do that on the record in the minutes. You can even have a speech about why you're doing it, and it's recorded in the minutes. We're even putting it on video. So the need to have that, in this instance, a rule passed saying you're allowed a paragraph would mean what? A second letter is sent, or a piece of the letter says, there's a few people who don't agree with this. It just doesn't make much sense. So this is the signature portion of it. So that's when signatures appear, it's in letters, right? Because that's a common practice for a letter. We don't put signatures on reports, but what we do with reports is list the members that were on the committee that did the report, right? So this is one of our most recent reports. It lists the work group members and whatever commissioners. So when the commission adopts it, we don't put their names in the report because they're just confirming a report, is in line with the work of the commission. They agreed to it. They didn't do the work. So only the people who do the work get the credit in the reports. So this is what a report typically would look like. It would have the people who worked on that particular report's names on it, right? But it would still, any official communication that is a report or a recommendation does need a vote. So that's where, again, if you didn't agree with the report, your dissenting opinion would be included in the minutes of the meeting when the report came forward for consideration. And then the last component of it is if we did a press release that was voted upon. Press releases do not have names, so they are speaking for the commission, right? They don't have a list of who voted for it and against it. This is what a standard press release looks like by our office. It just says the Cleveland Community Police Commission, and that's what the signature line is. It's represented that if we were to do a press release that wasn't something that's in our bylaws that is a turnkey press release, that was something that had to be crafted individually and voted upon, then this is how it would appear. It would just appear as text with the Cleveland Community Police Commission. So again, there's a lot of questions about where your dissent would come in, particularly in a work group report. So I think I mentioned it in the email, which I just closed. But if you're looking at this report, right, if you weren't a committee member, right, and then you had a lot of dissent about the report or work of a committee, it's a very unusual practice to have somebody have space in a report to be able to provide a counter opinion to it. I don't have any examples, nor can I find any where that's a common practice, right? You're either voting it up or voting it down, and your dissent is recorded in the record if you agreed with that report or not. Now, we're not limiting your ability to, we've already, as we're going through these rules, we've already said that, we're not limiting your ability to express your opinion in any way. So could a commissioner comment on concerns? Sure. We're saying that, but you can't speak for the commission, right? You're speaking as an individual. And I don't think we've limited that in any ways in our rules. You can do it in our meetings, and you're also free to do it. We're not restricting free speech. You just can't say, the commission when you're speaking. So that's what I summarized in the email when Commissioner Donaldson asked that question, and that's been our past practice. So this is a new territory for us, and again, I don't see any boards that allow for that. Courts are different. We're not a court. Appellate courts will allow dissenting opinions, but we're not an appellate court in that way. And we haven't set out our hearing standards yet. So if that's the only place where we would, if we want to revisit this when we're considering discipline, you can revisit this question when you're doing that specific rule if you want to allow for room in a hearing for that kind of thing. But in this general communications, that's been the past practice.
Thank you, Ms. Kubrick. Is any other concerns? Is I'm going to questions, discussion? Mr. Donaldson, you look like you're.
Yeah, I was trying to get my thoughts together. So I'll just say that I have been thinking about this, and I personally don't think there should be space to write any sort of dissenting paragraphs or however you want to say it, especially within something that's coming from the entire commission. As Interim Director Jason Gilbert said, your discussions are public, our meetings are recorded, minutes are public. Everything is out there already, and so I don't see the benefit of then adding an additional dissent in text form when it's already out there. The other part of it is that I think we should be very careful about that, because if we do allow this, then we also have to think about timeline and timeliness of this, which I mentioned at the previous meeting. And then we also have to think about, well, who will be the person writing the dissent, and then will it be fact checked? Because the last thing you want is someone to have information in their dissent that could be challenged. So having that out there, I don't think will be a good idea either. And then even if we do decide to move forward with allowing that to be in text or however, who's going to do the fact checking? Like, how are we going to? And I know that one of the things that came up also was just trying to determine when you're voting or you have opinions about things like who's right, who's wrong. I don't think that should really be the question. It should be more of like, is the decision or whatever was decided unbiased? And so I also wouldn't want for dissents to be seen as biased. So I just think when you're thinking about the entire commission and what our role is and what we are here to do, I do understand that there will be people who have differences, but I don't think we're muting those at all through our practices and our rules. I think we still allow people to talk about their differences openly and in the public, and it's all out there. It's recorded, it's in the minutes, it's everywhere. So I just don't think that for what we're trying to do, that there's space to allow that. Even if you look at the letter itself, like if I'm looking at the example that Jason sent us, I just don't see how that would fit into this unless we somehow put it in the body of the letter. But even that, I think, could be confusing to people who are reading that information. So, I mean, I'll just, in with that. But overall, I just don't see the benefit of adding that or having that space.
Chair Rodriguez?
Thank you for providing that clarification. From what I've observed, it doesn't seem like our names will be placed on all the reports, only when necessary and when it's appropriate. So I'm trying to think, be the devil's advocate. So maybe that was a point of contention, that if I wasn't working on a group, then I wouldn't want my name, because I'm just trying to play devil's advocate. I don't know, but
Yeah, I think you can clarify that they will not be on there, right? It's only certain documents that would require all of the names.
That's correct. So your name is not on a work you didn't participate in, but your vote carries the work forward as an official document, right? That's never been a past practice. But letters that are voted upon by the commission, your name will appear, and your name appears in our current stationery, listing who is on the commission on the letterhead too as well. So that's mostly where you'll see names appear, and letters are something that have only happened a handful of times, so they're a more complex decision that will require debate and take some time to think through. So.
Okay, so if I may follow up on Chair Rodriguez's concern. So I've thought about this a lot, and to be frank, during the meeting, I could see honestly both sides of what they were saying. So I did a little bit of, soul searching, and also try to get some opinions from people that may be able. I think the problem here is that we're trying to predict what will happen in the future, right? We're trying to manage it at this point. So what I gathered, from two lawyers, is that there's no legal liability that they see, because as long as we maintain factual information. So that's another consideration I had, is we can't predict the future, and we can't predict what the dissenting paragraphs will be and who will be writing it and what context they will be in. However, I just want to propose a different way to think about this. There is, of course, I hope they, even the members that brought this up, we're not trying to limit anybody's speech, right? It is true that there's multiple avenues with which we can express ourselves. However, I just want to let's think about the scenario that we have dissenting view, and it could be a very close vote, like a 7-6 view. To go back. So the real consideration is, how will the public perceive this, right? If there's, as long as that we maintain some level of honesty, there should be no legal liability. It's about the public's perception. Mr. Goodring, if you can, and how unified we are. But if we dig a little bit deeper into that problem, I think the issue is that if we have dissenting members, we already cannot control with this rule unless it's a high profile event. Even then, I'm not sure what censure would do in that case, right? In the high profile events, they are only the two co-chairs can speak to the media. Unless we delegate. But so the scenario, even then, right, it's not clear to me what the censure process would be for that. We haven't designated that. So I'm preparing for the potential scenario. So the risk analysis here, do we want people dissenting to be able to talk to their friend, go to the meeting themselves, because they don't feel, it's about feelings here. If they don't feel that they've been given the space to speak about these things, what are the consequences of that? Second, if our desire is to express unity, we need to create unity. We can't just cover it with a blanket, we all signed this. So I'm not playing devil's advocate. I'm actually thinking this is a real scenario, not to dismiss, what you were saying, but this is a real thing that we have to deal with as a commission. I think theoretically, I'm a little bit, the more I think about it, I was like, it is important that we have unity, but they know that we're 13 different people with diversity of opinion. I don't think we need to hide that, as long as it's factual. So my concern is if the diversities of opinions from life experiences, everything else is important to us, we need to make sure that value is also inclusively fulfilled. It seems like sometimes we are, and we're at a conflict here, right? We have a majoritarian process of just majority rule, and then we want consensus. Those are in slight contradiction to each other. I'm not proposing anything necessarily changing about this, but we need to think about how do we actually create that. Consensus doesn't mean that you accommodate the person. Consensus means that you listen to them, you take in the opinions, and you can still have the majority opinion there. And this is my concern about something written like this. So what was proposed by one of my mentors when I spoke about this scenario was this, that there would be, and he's a lawyer, so lawyers are used to dissent, they're used to arguing, and there are also a lot of things that occur between them are confidential. He suggested a space for the dissenting paragraph, but that there would be a process determined with which the majority will be able to evaluate that dissenting paragraph, a veto power even, with against inflammatory language, against misuse of rhetoric, against factual inaccuracies. So it would be, that we would have a draft process of that there would be checks on that. Because my concern really is if we just blanket, and I understand the outcome, where I think we're all seeking the same outcome here. But do we want, people, whether it's real or not, their feelings that they're not being heard and they go away? It's not like, to me, it's just not, if I'm making myself clear, it is not really unifying. It is really not building a sense of cohesion. Cohesion doesn't mean that we agree. So it seems like we're doing it by fiat, by power, by the majority of like we're building a forced consensus. That would be my concern. So I open at, I'm sorry if I was long-winded, but that is my concern.
Oh, okay. So I think I'm basing it on the type of information that was just shared by Jason. And after reviewing it, I really, if as a commission, we're going to say we're going to have this letter as a unit, there may be some dissenting opinion, and I think that's fine. However, I think we're all going to be in instances where we're going to be in the minority and we're going to have disagreement. But I believe that we took an oath and a charge to move this work forward. So it's not always just about me and what I believe, especially in this work, right? So if it's personal or something, that's something different, right? We all have different ideas and beliefs, but we come together and I think unanimity, being in unity doesn't mean that we all agree and that we're all unanimous, right? I don't think those are the same thing. I think we agree to disagree. And I think we still operate, we still move in a professional manner. I think we all have, it's going to be instances where I'm not going to be heard and voiced. I think we have the ability to accept that and understand that, be open to different perspectives as well, I guess.
Thank you.
To the chair, I think a more accurate way to describe dissension on an issue through a vote is the vote itself. The nay vote says that I don't agree. It becomes part of the record. Additionally, our meetings are right at this moment are recorded. They are remote. The public can hear the dissension as it is raised within the context of a meeting and within the context of a vote. So it isn't that dissenting voices do not have an opportunity to share that and do not have an opportunity to share it with the public, because we have all of these check and balances to make sure that they can do that. And I think there are so many instances in life where there is not 100% agreement, but a group, an organization, a board, or a committee move with the majority. And it does not say that there are some dissenting voices. We have recorded those voices in a nay vote. We have recorded those voices in our minutes. We have recorded those voices in our remote recordings. It's there already. But I do believe strongly that we should move forward as a unified commission. If we are not together as we move forward, how do we expect the community and how do we expect the police department to have confidence in our ability to move forward as a commission? And those dissenting voices have been recorded. I do not believe that we should set aside anything that will allow a dissenting voice, as in the Supreme Court, to mention that within something that we're moving forward as a commission. And the one point I do want to make on as far as speaking, the co-chair speaking for the commission, on high-profile issues, we are basically acting at the direction of the city. It says here, we take our lead from the city on high-profile situations. We aren't just over here determining what our response would be. We take our direction from the city. And that way, we are in unison. The voice is a unified voice in terms of how the city of Cleveland approaches the situation. And we are an arm of the city of Cleveland. So even though we act independently. So I think that's important to note, that we aren't over here making an independent decision on high profile issues. We take our lead from the city.
Right now, to just help the audience, which is a very important issue in listening, clarify, I would propose that somebody read this entire section. Who would like to read?
Which section?
We're gonna start from the
I would like it read. So just because I see some of our audience members trying to read, when we're taking this a little bit out of context here. So to explain the various elements. So
I'd just like to make one comment to the chair because I have to leave. I'd already notified Jason that I had to leave at 6:30. I have another engagement this evening. On the record, I don't know how this would be ultimately resolved, whether we have to go back to a motion from within this group, either saying we stand by the earlier decision to move this rule forward as it was initially done, or we make a change within this committee to change how it was presented to begin with. But as for the record, I stand by the decision. I can't do proxies. I know that once I'm gone, and if there's a vote, I'm out of the picture. But I do want the record to show that I stand by the decision that was made earlier.
thank you, Co-Chair Ridgeway. Does somebody want to read or?
Well, I was just going to say, before we go back to reading, I just wanted to add that, I just wanted to reiterate, because I think I said earlier, so when you're looking at the example that we were sent, for example, the letter that was sent to the Department of Justice, this letter, from what I'm reading, was based on facts. There were people who were not interviewed. There was an investigation that was inadequate. So I guess the point I'm trying to get across is if we're going to be sending out these type of letters, I would hope that what we're saying in this letter is all based on facts. So I don't understand how someone can dissent from facts. So I really, really want to reiterate that I don't see a spot for dissenting within this type of example, because this is based on facts. The example that was provided. I do know that, there could be, other scenarios, and we might be sending letters that aren't related to this, but I'm just using this based on this. So what I'm basically trying to say is that I would hope that whatever we're saying is all based on information that we've gathered. It's all based on facts. So I don't think there's a spot for people to want to dissent from this. And if their dissent is based on facts, then why are we even sending out a letter? Because then you have a conflict, you know? So I'm just not understanding why this would need to be included in the letter. The other thing I want to say is that maybe we could look at rewording the statement in the manual. Maybe that could be said better. Maybe we could say written letters approved, because we've said that reports may not necessarily contain a signature. So maybe we could reword that verbiage to make more sense to what we're trying to, get across. But again, in the example we were provided, I'm just not seeing how we can dissent from this if we're sending this information out based on facts.
So I do see a problem with actually that letter, if we can bring it back. We have, it is not 100% a statement of fact. For example, if you say therefore, therefore the Cleveland Community Police Commission believes that the investigation into the death of Arthur Keith was woefully inadequate. That is an assessment, and resulted in a denial of Mr. Keith and Mr. Keith's family's civil rights. That is also something that has not been adjudicated. So whether I agree with that, right? And the request is fine. I can see someone's, for example, like, not to isolate him, like Mr. Fulmer, who is a representative of the union, this could provide a possible problem for him. So his job is to defend the police officers. Now his name is attached to something that designates, I don't know if it could be used legally against him. I have no idea. The other thing is, Mr. Goodrick, it seems like we probably need more discussion on this, if I'm correct. Could we get a copy? I agree that this letter is basically fact. Could we get a copy of investigations or something that they disagreed on, like an investigation finding? Or
to the chair, I mean, the examples are what I gave you here. So we didn't do our job wasn't to do investigations. So that you're asking for something that didn't exist.
Exactly.
So we did policy work, and then we were determined to be by the court free in thought. So this letter is expressing your freedom of thought, right? So the commission had the right to say, we don't think there was justice here, and they opined on it, and this letter was drafted, and then it was discussed, and yes, that was the conclusion that they drew based on fact and agreed with by the majority. So that's the process you're looking at here. And to your point, yes, Jeff Fulmer's vote is recorded as a no, but again, Jeff Fulmer is a part of something bigger than Jeff Fulmer, So, if Jeff Fulmer really wanted to protest, he could resign from the commission and say, I don't want to be part of that bigger thing, right? But in this instance, regardless if and in our history, typically, with a few exceptions of the Black Shield, the majority of the time, the police voted in a block, and the vote was often a nay against everything. So what I fear is two things. You'll see two commissions form, and they'll follow you everywhere you go, the dissenting commission and the majority commission. And then you will also have the media, and the stories will focus on the dissent, not your work. And so I know those are experiential opinions, but those are things that I believe are risks that you take when you go the route and change what we've been doing.
So I do have, yes.
May I be heard?
Yes, after Mrs. Ridgeway, go ahead. Please come to the microphone, Mr. Jackson.
We have a mic over there.
Do I have to stand?
You don't stand, whatever you feel comfortable.
Thank you, Madam Chair. To the chair, I think what a lot of people are missing in this situation is that the prior commissions only had recommendation power. That was the extent, and even recommendations were almost stretching it, even though the consent decree explicitly gave that ability for them to do so. Letters like this were allowed to be to have some feeling and thought into it, and their beliefs, and of course their assessments of what took place, because they're only giving recommendations. the overwhelming issue here is that you guys have the power not to just give recommendations, but to actually demand and correct. And because of that, you really have to, your letters will not look anything like this. Your letters will have to be all about facts. Additionally, while we were able to speak out on things more often, you will not, regardless of where your personal beliefs are, because you're an entity that will ultimately have to rule or may have to rule on something. You can't go out to the public and speak as a block or as individuals, because it's just not in your purview. Your power is to actually stay above the fray and actually look at the evidence and make those rulings. To the issue that you were speaking about previously, and I'm sorry I'm late getting here. I work late, but the issue of the statements was another one that was problematic, because while you may want to have your opinions as individuals, I may take some flack for saying this, but having been a Marine and having been a police officer, I've always had to take an oath. And in taking those oaths, I can no longer be just Richard Jackson from the block. I can't be that. I have to be whatever it is, that oath that I took. So do you. So because of that, whatever your personal beliefs are have to go out the window when you're doing this work. That being said, there are going to be times where some of these issues may end up in arbitration. They may end up in court. Your additional statements that you make in writing are there forever. Yep. Of course, all of this is still there forever, but those additional writings are there forever. Like the co-chair stated, that nay vote is fine. That's fine enough as your statement. If you have something about the segment of the community that you are here representing, and you want their voice heard, and you are here as that person for that segment of the community, make your issues known right here at these committees. This is where the work is done. The work groups, the committees, that's 98% of it. When you go out there as your entire commission en bloc, you guys are there just to do your duty, to vote on the issues that have already been vetted here. If there's something new that comes up, then of course you have the ability to send it back to committee, wherever committee it came from, and look at it some more. But as far as being out there, that's just for you to come to the public and make your vote known. If it's a yay or nay, fine. But all of the other stuff, really, that's not for this entity. That's for individuals. And you're just not allowed to be individuals. I'm sorry, but that's just the way it was when you took the oath. So that's all I wanted to say. Thank you, Madam Chair, for the time. I appreciate it.
Thank you so much. Ms. Benito, finally.
Thank you, Sergeant Jackson. We're very grateful for you. I think that I'm not sure that I really have any more to add. I think Sergeant Jackson kind of addressed my biggest concern was the potential of endangering the work that we're doing. If there are dissenting opinions, if there is marks of disunity on the decisions that we're making. And I agree with everything that has been said, that it is important that there is opportunity for collaboration outside of the meetings where we are talking to one another. I think it's important that there is opportunity for public discussion, which there is through the meetings, both committees and our full meetings, that there is recorded information about dissent, which there is through the recordings of the minutes and also the recordings of the meetings. And so I do believe that the rights of members to voice their concerns and voice their dissent is protected. I would like to actually propose that, I like actually, Commissioner Donaldson's, comment about that reports don't have signatures on them. So I would actually move to say that written, I think statements covers both press releases and letters. And so I would say written statements approved by the majority of the commission. And I would actually move to minus that amendment to approve it to bring back to the full commission next meeting.
Okay, so we have a motion. Do we have a second?
I second.
Is there discussion?
Just a point of clarification, we're removing reports and just saying written statements approved by the majority of the commission shall include the names and or signatures of all commissioners regardless of their vote. Is that the motion?
So, Mr. Van Leer?
Yeah, I was gonna make this statement before you made the motion, but I strongly support the conversation that's happening here. I think dissenting opinions are what happens during conversation and vote. So I'm not gonna rehash what everybody said, Sergeant Jackson and everybody else has said that. I agree with you. I am concerned that taking reports out of there, I think reports are not statements. I think we should be as expansive as possible on this, but I'm not a voting member of this committee, but
I think what it's saying is that reports don't have signatures, and it's referring to signatures.
as long as we have clarity on what we
What a
need
statement is,
and,
yeah.
and
I think
because I think what I supported also with Jason, how Director Goodrick described past practice. I think that's,
So
So-
the word is and or, so it doesn't mean that a signature is included in everything. Signature is appropriate for a letter, which could be a statement, right? So that's why it's an and or.
so if we're silent on reports, will that raise an issue later? If somebody will say, well, this doesn't say report, I'm just asking, I don't really know
So
yet.
it sounds like all the commissioners' names aren't included on reports, just the people on the report.
It depends on the report, though.
So the report's names are the people who worked on the report, right? So I don't think anyone's going to contest that they want to have their name added to it if they weren't part of the work. But so I didn't think that deep into it. So I just put it that way because your name and spirit is on it if it passes, quite frankly. So
To the chair, what about a work group with a commissioner on that work group who is not in agreement?
Mhm.
I don't know. I don't want to overthink it. I think we're overthinking this, so I'm fine with what you do as long as we understand.
So we
where
do,
we're headed.
I do want to know this may be revealing where I may vote on this. Everything that has been said about, the dissenting opinions are here, we have opportunity, is actually an argument for allowing the dissenting opinion in the majority, in the published reports. That doesn't make sense to me that you say, there's all this, obviously, unless there's not an equivalence in access from the public to that opinion. If it is given in a meeting, they have to go watch the meeting, they have to read the minutes of the meeting. Obviously, there's not an equivalence there. And I think this is what, I don't know, actually, this is what I am concerned about. And the other thing is, we still haven't resolved the issue of if you have people that might be dissatisfied and we haven't established a rule that says they can't go to the media by themselves. So you're actually not resolving the consensus part of it. We have to, I think, develop a mechanism that satisfies, makes the person and the dissenting people feel that they have been recognized. It doesn't mean that we have to agree with them, but it should be, I believe, a process of dialogue and maybe debate. I don't know. So I feel uncomfortable with saying flat out, all statements have to include signatures. So I'm not misunderstanding that we need to create a unified front. However, how we get there, I think may actually get in conflict with the unity that we want to create.
So, but I think that where we differ on this is that I believe that the process that we talked about, where there's there's discussion and opportunity, things are sent out for feedback. That is one way right, that consensus is built. Conversations that people have where they're calling one another, saying, hey, this is what's going on. All of those things are already built. In the fact that we have work groups, right, that's another avenue where people get to have a larger say. The idea is that someone is choosing their work group or their committee based on the areas where they feel like they have the most expertise and interest, right? That is another opportunity for people's voices to be heard. So I think that where you and I are differing on our thoughts on this is that I believe the processes that we already have laid out, everything from committee to the Robert's rules that we use, where there is space for debate and there is a recording of votes, there is roll call voting, right? That's another way that people's individual voices are heard, as opposed to just a yay, nay, recorded 3, versus whatever. I think that all of those are when you ask how we protecting this, to my answers to that is all of these different things that we've already laid out.
Mr. Johnson, Mr. Johnson.
Yeah, I just want to add again that I'm just not seeing the benefit of adding options for people to dissent within statements. Going back to what Sergeant Jackson said, we have to remember that we're different than the previous commission. So there will be opportunities or situations where what we release could come back. And so I just think it's really, really important for us to remember that whatever we are putting out to the public, especially in written form, cannot have, as much as we prevent, cannot have any opportunities for us to be involved in some sort of situation where the information is incorrect, or we are now being attacked for our credibility or our integrity. So I just don't see the benefit of adding this option when you already have the ability to speak openly about your opinions. Your minutes are recorded, everything's. So I just don't see why adding that additional step. How is that going to benefit us as a commission?
So to reiterate what my suggestion was, I do think there is a potential benefit because it actually builds consensus, which again is not full agreement. We're not, acting like the Quakers at this point. They don't move forward at all, until, and it has its benefits and it has its detractions. But the benefit I see is that we do, because I do understand, I'm not encompassing what the other two commissioners said, but there is this term, the tyranny of the majority. My concern is that the majority opinion also needs to be factual, and there needs to be a check on that. One of the checks you could have on that is the minority dissenting opinion. And we should be working in concert. I'm not suggesting we just let someone, write this, but there could be a dialogue, because I'm trying to, include a process that forces us to actually talk these things out. I think is very edifying for the community. I do not think an up or down vote explains the rationale of why we are, and these things, I don't know if they're going to be 100% clear. And I'm going to be in the majority sometimes, I'm in the minority sometimes, but I really do believe for those two entities. So we haven't, to my understanding, dealt with the fact, how will we, unless we put a rule in, I want to reiterate, unless you put a rule that says once the majority, we can't do that, because the rule would have to be once there's a majority decision, you can't go out into the press and say something else. And we're obviously not saying that. So you have to bring that person back into the fold in order to create the unity that we all want. That's what I'm trying to convey here. There's no, I don't see any other process with which we can force that type of unity. And the more we force these things, the more, that it actually can go astray. So we have to evaluate what is the risk that when we pass this rule, what is the risk of the dissenting going out and talking to the media? That is a real risk, right? That's what we're trying to manage here. However, what we're doing may actually foment that even more. So that is my concern. But we do have a standing motion to vote up or down on this, right?
There is a motion on the floor to move this back to the next full commission meeting for an up or down vote in adoption of this section with this new statement, with this new sentence. Written statements approved by the majority of the commission shall include the names and or signatures of all commissioners regardless of their vote. Yes, there is, and point of time, we have 10 minutes
Yes.
left,
So we
have a motion to move this forward, and
can call for a vote, right? So I'm calling roll call vote. Ms. Benito,
Aye.
Mr. Donaldson,
All right.
Ms. Rodriguez,
Nay.
and I vote nay. So we have a tie. What does that mean?
we currently do not have a rule for a tie, so we're not a pass. This is
The reason why I said nay is because there seems like there's a lot of,
Yeah.
even in this committee, there is a lot of, so I actually agree that we should
Should
be
continue.
in unity, right? But I think this will continue in the full commission, so that's why I voted nay.
Robert's rules, it tells you what to do when you have a tie.
yeah.
I decide, is that what it is?
We don't have a tie-breaking bylaw right now, so give me a moment.
But I guess
And
clarification.
That is my clear, I'm not trying to like stop this, except I think it requires further discussion. I'm not even clear what written statements means at this point. I want to encapsulate what, Mr. Van Leer's concern that reports was taken from this. I just don't think we can cut and paste everything and get to this. And I know, your desire is to move this forward, but I don't think that is trimming this and pruning this is the way, because we need to really deal with the deeper issue. How do you create unity in a way that's inclusive?
I'll just add that to the chair, I don't believe that a statement or a letter and signatures is creating unity. Like, I think that's two separate things. So I don't think this issue that we're debating right now is going to somehow bring us together and unite us. I think this is just something that we need to decide in order to move forward and have it in the manual. But I think it's two separate issues. I don't think a letter or a statement is the place to want to, create unity and in that sense that you're, explaining.
Yeah, and I agree with you. My concern is what other things it could create, this rule. So, Ms. Benito?
I think my concern with where we are right now, and I think that I can acknowledge that just changing it and then moving it to a vote was probably a little hasty on my part, so I can own that, especially because I do think that, especially with the breakdown of these three different types of different types of statements, right? And it also won't be all inclusive. Like, we don't know exactly what's going to happen over, the life of this commission. So I just will own that. I think my concern about where we are right now is that we have a lot of really important rules to get through. And I'm not sure that the discussion that this has turned into about how do we prevent people from going to the press, how do we create unity, how do we make sure people feel that their voices are included, I think those are important issues. I don't think that is what our discussion should be. I think that this is about when the commission puts out publications, do we split it? Do we say that this is only endorsed by certain people, or do we not? I think that the questions that we need to be asking are about how does that impact the work of the commission. I think look, everyone here knows that I am touchy-feely. I'm a social worker. I want everyone to feel included. I want people's voices to be heard. I completely agree. But I think that the number one charge that we were given was to advance the work of police accountability. I am more concerned with how the dangers of some of the changes that we are discussing, how that can impede the work, more than how might it. I think we do have a challenge on our hands of how do we create unity in this commission. I think it's absolutely a challenge, and I think it's a worthwhile one. And I absolutely have full faith that we will get there together. I think that I just feel strongly that, even if we change some of the wording on that, I do think that I don't feel like I can move on this. I also believe that belaboring this for basically what we're talking about, then having an additional meeting where I'm not sure how much we can really move on this. Then we're talking about not looking at other rules for about another month now. And we have a big rules package that is critical to moving the work forward. And so even if we are to send it to the full commission, and maybe it passes the full commission or it doesn't, my concern is that I don't want to hold up the entire work of this committee with this one issue.
If on the half does not constitute a majority, if therefore the motion failed.
Yes.
So, and just warning, 5 minutes. before we
Okay, 5
automatically
minutes.
adjourn.
Thank you. So, unfortunately, the motion has failed. We had some other business that we had to get to that regarded voting. So we are at, unfortunately, a point that, Mr. Johnson, I'll get to you. I guess I'm in an effort to get, not to debate, but to move the situation forward. I'm a little bit confused as to the argument for this, and this is what I got back to before. The argument for the signatures being improved is unity, but now we're saying it's not about creating unity. Do you see the conflict? Before it says we want signatures included for a sense of unity, but Ms. Benito said that this is just about advancing the work. I think those two things are intertwined. So is it about, my only concern is if it is about creating, let's not use unity, consensus, inclusive consensus, then I think we need to develop a process for that. And I don't know if a one sentence rule is going to do that at this point. That is my concern. So Mr. Donaldson and Ms. Chair Rodriguez.
Yes, to the chair. I know that you spoke with commissioners individually about this, but did you receive any feedback, any input, any suggestions emailed to you or, sent to you after our last full meeting?
I did not receive any email, so I started, I thought that the committee was, and I myself, it's not like a flip-flop, I thought about it more. I was, again, in the middle on this. And then after speaking to people, I would say that there were definitely people, I haven't spoken to everyone. And I have to say there are people on the fence, and I'm a significant number. I don't know exactly. I have not been able to speak to Commissioner Adams because he's away in Chicago. I've not been able to speak to Commissioner Garrett Ferguson, who are the two people that brought up this. I've spoken to other people, and I would say it is a mix. There are people that, okay, let's do it, let's have unity, and there are people that I'm in the middle. So I don't know. I wouldn't be able to, and I apologize that it's continued the process late. But I thought that there was more consensus that there was out there. So,
and the only reason why I asked that question is because I really believe that if commissioners had a strong opinion about this, either way, that they would have sent you the information. We clearly said at the last meeting to send you suggestions, input. So I'm just not seeing why there's continuing to be a holdup on this if you are having to reach out and get that information versus people sending that to you.
I understand, but we have, I've done that multiple times, and then
So,
we get to the
I would say
commission.
for me, having the information that was provided to Commissioner Donaldson on the types of reports, that might provide some further clarification, because written reports, that's general as well as statements. And I know there was some contention with the Nichols, that letter. And so they may have been thinking about that. So I think definitely being on the same page and providing information might provide clarification, but just to provide about unity, I guess from my understanding, even when we have various issues and topics, I come under the understanding that we will not all agree. I will not be on the same page as everyone. However, even in those instances, if the majority, and in some cases, the supermajority with police accountability, that, it's not silencing your voice. In this particular instance, I may not be in favor. It's okay. Maybe in the next scenario or the next vote, I may be on the same, but I don't want it to see it as, oh, you're the majority or you're not. For whatever reason, the overall commission feels that this is the best manner to move in this direction. So I guess that's how I see it. It's about what is best for this practice or this commission. It's not always.
We are at 7 o'clock. I will allow one more brief comment, and then we will have to adjourn the meeting and continue this discussion. And I will add, I will hopefully limit this discussion next time and add more things. And to address Ms. Benito's concern, we're able to pass separate sections and move forward. So this is an important section, but we are able to pass single sections next time. Ms. Benito.
Yes, I hear that, but also if we are continuing to discuss it, then we can't move on to subsequent sections. I just wanted to add in that I did receive a message from Commissioner Zayed that said that if the dissenting opinion statement will be discussed tonight, I would like to note that I'm not in support of it. So just because she asked me, I just wanted to make note of that.
Okay, so we are going to adjourn. Thank you for your time and thought about this, and we need to determine our next meeting.
Oh, yes.
Please.
I'm ending the stream.
Thank you.
Just because I don't need to know